All right. So I found a house.
Mhm.
I've negotiated my purchase price. What piece of paper is going to get involved at this point between me as the buyer and the seller so that we can start our purchase process?
Well, in Mississippi, for you to have a contract for the sale of real estate, it's got to be in writing. That's statute of frauds. That's on the bar, every bar exam.
Hmm.
So, just shaking hands and saying we've got a deal. Well, if everybody does what they say they do, maybe you do. But typically, when make that deal, then you've got to close the deal, right? You got to get the deed, you got to
Right.
change money's got to change hand, all these things. All of those things typically are going to happen at either a real estate attorney's office, or if you are using in-house bank financing, sometimes the bank will have the attorney do all that stuff in the back office, and maybe you'll close at the bank. But if you're dealing with a cash situation, you're going to have to interact or do something with an attorney to make sure you've got the deed and all of that's done.
On just the contract. So we got to have a contract.
Mhm.
The old school handshake's not
Yep,
any good
that's
anymore for it to stand up in court. Okay. And that contract is going to outline what about this purchase?
from a legal perspective, it
Mhm.
needs to be enough that you can sufficiently determine what the deal was, right? Now, that doesn't have to be a whole lot. In fact, there's case law of people writing things out on napkins. I've seen a few napkins in my day. And you know what? That's perfectly legal. If somebody tried to back out and there's case law on that as well, that napkin may be enough to say, no, we've got a contract. So, on the one hand, be very careful as you're dealing with people, because you may be having drinks and having a good time and talking stuff and not really mean what you're saying. But you start writing numbers down, you might better mean what you're saying, because it could be
Right.
interpreted. So number one, be careful of that. Number two, you know, technically, to have enough information to clarify your deal, you need an address, right? Property
Mhm.
address, sales price, who the parties are. I
Mhm.
mean, technically, if you've got those 3 things, arguably you've got a contract. From my perspective as an attorney, I'd like, the more the better, right? Things like, when will possession be delivered? Typically, of course, that's at the closing, sometimes not. Is this an as is sale, or is it subject to some inspections? Typically, in an investor's context, you typically are dealing with an as is situation, because
Mhm.
investors understand that's how you get the deals. When you go through all of the contingencies, a lot of times that's where you'll miss out on the deal. So
Right.
most investors understand, but still have all of that. Maybe something in particular is being left, maybe it's not. The specific terms of the deal, if it's already a rental property, an investment property, are you going to get prorated rents? What about security deposits? Those kinds of things. If a mobile home is involved, and this is probably the biggest mistake I see a lot of pretty savvy investors make, not realizing that in Mississippi, a mobile home, which mobile homes can be more profitable than houses. We started out making art. We don't have a lot of I don't think we have any now, but when we started out, we had a lot of mobile homes because you could make a really nice return cash flow wise on
Yeah.
your. Well, in Mississippi, you've got to have a title, much like a car. And so a lot of times I'll see these contracts, and of course, you've got the real estate in the mobile home, and it doesn't say anything about a mobile home even being on the property. And they'll get to closing, and I have seen this, and I'm like, whoa, wait a minute. We got a mobile home. We need, we got to get the title, or if the title somewhere, handle all of those things and make it clear. So, if a mobile home's involved, reference the make and model of that mobile home, where the title is. If it's, if there's a lien holder that has that title, the process would be that you pay off that lien holder and then you negotiate the title, just like you would on a car.
Right.
Those things that, and I can tell you, and anybody that has dealt with MDOR, which is the Mississippi Department of Revenue that titles mobile homes and vehicles, if you mess around and don't have that, and if something happens to the seller, that can be a real problem. When you get ready to sell it, in particularly, those are just those kind of the more the better. You can get a very simple real estate sales contract, usually either from an attorney or probably online, that will, check all the boxes. But really think about, and hopefully, if you're investing, you've educated yourself to know the kind of things you need to be thinking about,
Mhm.
and try to get all of that in there. And the bigger the deal, the longer that may take. And it's easy to get impatient, but buying one house on a lot from somebody that's retiring or moving away is a different deal than maybe buying 10 or 15 houses from an investor. Though that's a different process. And so you just got to be patient and maybe have several meetings and work through that process and get it all written down. And most importantly, what I always tell everybody, just make sure everybody's on the same page, because
Right.
what you don't want to happen is there to be a misunderstanding because something didn't get put in that contract, and then you get to the closing table and maybe somebody walk after you've extended a lot of effort and time in a situation, particularly if you've got something that's contingent on appraisals. Well, appraisals are not cheap, and maybe you've spent a bunch of money on appraisals and now you're not going to get the property. So maybe maybe it didn't say, and the buyer paid for the appraisals and now it's a no-go, as opposed to protecting yourself and saying maybe, hey, we'll split the cost of that if this deal doesn't pan out, because that way the seller would at least get a copy of the appraisals and they would have some value in it. There's just all
Right.
kinds of moving parts, but the short answer is as much as possible.
Yeah.
But the
Yeah.
legal answer is it may not be as much as you think. So when you start writing things out, be very clear. If it's not intended to be a contract, hey, we're not contracting here, we're just dealing, we're just negotiating.
Right.
We're not
Right. Yeah.
be very clear and make that clear, because there is absolutely case law where maybe one party was more serious than the other and the selling party's like, I didn't mean that, and there was enough written down to say maybe they did. That includes texts, emails. In this world we live in, I have seen people bind themselves contractually via text. So just be aware
Wow.
of that, especially when you're going back and forth on amounts and negotiating. So just be aware of that and be careful. And as always, seek all of the legal and professional counsel that you have access to.